Thank you.
Your Ladyship, just for the record, Your Ladyship, may it go
Yes.
on record that my client, the first and the second respondents, are constitutional office holders. They will abide by the orders
Yes.
of this court and indeed any other court in the Republic.
Sorry?
They will abide by the orders of this court and indeed any other court in the Republic. They respect the solemn oath of office they took to respect any orders that this court and any other court may give. So the issue of the independence of the judiciary, the issue of intimidation that the petitioners are harping on is nor here nor there.
Independence of the judiciary and what?
Independence of the judiciary and intimidation that the petitioners are harping on is nor here nor there. Our client will abide by the orders given by your court, Lady Justice. That's the first point. The second point that we want to make, Your Ladyship, I was involved in E080 of 2023, E080 of 2023, that is the CAS matter, the consolidated petition. And the reason why the court did not stay those orders when the prayer was made after the judgment had majorly to do with the fact that the court had given a negative order, a dismissal, which is a negative order. But Your Ladyship, if you look at the orders of this court today, the orders that you have given in the notice of motion by Mr. Omtata, they vary from 1 to 6 orders. And Your Ladyship, those are positive orders mandating my client to undertake certain actions, prohibiting my client not to undertake certain actions, mandating certain institutions not to undertake certain actions. So the accommodation we are asking for, Your Ladyship, is not a review of your order, is an abeyance, a temporary stay for 7 days to allow my client to be able to, number one, move to the Court of Appeal, but importantly, to be able to adjust his situation or circumstance. You will appreciate, Your Ladyship, that the Finance Act had been negotiated and public participation has been going on for a period of time. Certain institutions, based on the bill, made adjustments to their systems, to their processes. If the court has now stayed those provisions, Your Ladyship, my clients needs that time, not only to move to the court, but to be able to adjust their situation. And how are they able to adjust their situation? Number one, if it is the court order that the additional revenue is not collected, then that means that my client has to look at the expenditure and the appropriation, because the revenue will not be matched with the expenditure now. Number two, if you look at certain provisions of the Act, like Section 47, it mandated the KRA to undertake electronic invoicing. So certain institutions have to also...
Could you please repeat? Section what?
47 of the Finance Act. It mandated the Kenya Revenue Authority to undertake electronic invoicing of goods and services. So these institutions within those 7 days...
Mr. Somane, I'm struggling to keep up with you.
Yes, Your Ladyship, I will go slower.
Remember, Remember,
very
we're not
sorry.
having we're not having a conversation. I'm listening and then writing, eh?
Okay, Your Ladyship, I am very
All
sorry.
right.
I speak too fast generally, but I will try to.
So it mandates a KRA to do what?
It mandated the KRA to
Yes.
undertake electronic invoicing for goods and services. That's just a simple example. And Your Ladyship, that process had been ongoing for a period of time. Now that the court has given conservatory orders suspending the act, my clients need to engage these institutions with a view of transmitting this order, ensuring that we comply with this order, and even coming back to this court
To engage these institutions.
to transmit this order for compliance.
Yes.
And even come back to this court in the event there is any hardship in compliance. And the reason why we are asking for the 7 days is to just make sure that we don't have an avalanche of contempt proceedings against various officers and constitutional office holders before you, Your Ladyship. That's the second point. The third point I want to make, Your Ladyship, is a misrepresentation that has been harped on by the petitioners.
Contempt proceedings against constitutional officers before me?
And before you, and even before you and this court, for non-compliance with those orders.
Yes.
The third point, Your Ladyship, I wanted to make,
yes,
is the representation that the Finance Act was nipped in the bud and did not come into effect. Just for purposes of clarity, the Act was ascended to on the 26th of June, 2023, provide a Gazette Notice Supplement number 97 of 2023. So by the time the orders were being given, the Act was alive. And that is why, the proof of that is in the pudding. That is why Mr. Omtata had to amend his petition to include those provisions, various provisions of the Act. And in fact, if you look at the petition, he is very specific. If you look at prayer 2, and 3 and 4, he refers to those sections of the Act. So they are aware that the Act is alive, that the Act came on board, and we submit. Of course, the court has the power and the jurisdiction to declare any provision unconstitutional, but the Act came into force. Certain provisions will come into force before others, but the Act came into force through that Gazette Notice. And that is a very important point for the court in looking at whether to grant this abeyance. The last point I want to make, Your Ladyship, is the point that was made my learned counsel, Mr. Manzo, as it relates to Article 222B of the Constitution.
Yes.
The Article 222B of the Constitution allows the government to do appropriation up to 50% in the estimates. Our submission is brief on this point. These are exceptional, and it is very clear circumstance which allows the government to do that. In the normal order of things, an appropriation act is passed, and even if you have to appropriate only 50%, my clients will not know what to prioritize. And that provision is an exceptional provision in the Constitution for emergency purposes and not in the ordinary course of appropriation. Lastly, Your Ladyship, you asked a question which no one has answered. And this question, in fact, it is magnified by the prayers that is sought in the petition.
Yes.
The prayer, the question you ask is, are there savings provisions within the Finance Act 2023? The related question is, what are the fallback mechanisms for my client? If there was a prayer in the petition, pending hearing and determination of this petition, that the court grants an order that the Finance Act 2022 shall apply for purposes of revenue mobilization, we will not be having this conversation. We're having this conversation and praying for these 7 days because the court cannot give such a prayer. It's not in the petition. Parties are bound by their pleadings. And my client is stuck because they don't know how to move. It is the most sensible prayer to this court.
My lady,
Yes.
with your kind permission,
Yes.
I object to the kind of submission Land Council is delivering. The petition, my lady,
Sorry?
is arguing the petition.
Yes.
Right of to reply. He's arguing the petition is arguing matters of fact. Is delving into the merits of the petition, and yet at this stage he's supposed to be urging his case for stay, and he should be arguing the law at this stage because he's replying. I don't see why he's going into the merits of the petition and not arguing matters of fact.
Somane?
Your Ladyship, I'm not arguing matters of fact. I am raising the issues that have been raised in rejoinder because that was an issue that that counsel for the petition has raised
Yes.
as relates to what is the fallback provision. That is a matter of law. I know it's a difficult thing for Mr. Omtata, but that is a matter of law. And our submission here is very brief. There is no fallback.
Mr. Somane,
Yes, Your Ladyship.
I'm not sure that last comment was necessary.
Yes, Your Ladyship. Your Ladyship, with your kind permission, our submission is there are no fallback provisions on
Yes.
the Act
Yes.
as relates to what our client is supposed to do because
Yes.
of the orders that has been made. and that is not helped. The orders in the petition, as well as the law, does not say what are the fallback provisions. Those are our brief submissions, Your Ladyship, and that is why we pray for these 7 days to be able to undertake some of these issues that I have seen. With those brief rejoinder, Your Ladyship, thank you so much for your time, and thank you for accommodating us. Thank you.
Mr. Somane, just a question, a quick question.
Yes, Your Ladyship.
So
Yes, Your
exactly what will happen in the 7 days?
Your Ladyship, within the 7 days, we have to look.
Just a minute. And unmute yourself.
Your Ladyship,
Yes.
you have seen something that is practically before you now, and
Yes.
I will. You've seen that there's an application to cite EPRA, which is not a party here. There's the KRA is also a party. There are various entities within the Finance Act, okay, that are required to undertake certain things which they have already started. Within those 7 days, the Attorney General and the Minister for Finance have to go and, look at this court order, interpret this court order, and try to talk to those institutions on what needs to be done based on the order that the court has made. And Your Ladyship, if that is not done, we run the risk of 20 contempt applications against various government officials. And that is why we're saying within those 7 days, the Minister for Finance, who is a party here and who's filed a substantive affidavit, the Attorney General, will be able to advise these various entities because of the orders the court has made. I think it's a fair proposition to allow for that. Apart from the appeal to the Court of Appeal, which is a right of appeal, there's this other issue on the mechanism of enforcing the order of this court. And as I started, the instructions of our clients is they will abide with the order of this court, and they want to be given time to look at this order with a view of ensuring that they comply with this order. And that period allows them to do that, Your Ladyship. Thank you.